Good afternoon, everyone. Like Andy said, my name is Loishirl Hall. I practice in DC and Maryland, primarily in Maryland, but I also am barred in DC and work on a few cases there. My primary area of practice is real estate, but I do a lot of probate work in the real estate space. So I'm super excited to be back at my alma mater. Thank you all so much for having me. And I hope you all learn a little something about the importance of making a will and how to make one. So August is Make a Will Month. This is an annual campaign that really aims to raise awareness and really inform people why it's important to have one, what a will is, and just inform everyone about keeping their will updated if they already have one. So why is having a will important? Well, one, it gives you peace of mind. You have confidence that any of your wishes after you're gone are documented. We all hate to talk about that one thing, which is death. But I heard this quote, and I'm sure most of you have heard it as well. It's two things are guaranteed in this life, and it's death and taxes. So it's something that's going to happen to all of us. And so it's really important that any intention that we want to have regarding what happens to us or our assets after we're gone, a will make sure that that is honored. Another reason is that it helps lessen the stress for your loved ones during what often proves to be a stressful time for everyone. It reduces conflicts and it can minimize uncertainty for your loved ones. And the process of creating a will can be a lot simpler and affordable than people may think. Of course, if you have minimal assets, your will might be a little simpler and less expensive. And if you have a lot more assets, then your will might be a little more complex and a little more expensive, but depending on how complex you want the will to be. So here are some helpful stats. So in the US, according to the 2020 census, there were 258.3 million Americans, or a million adults, which means individuals 18 or older. And of those adults, only 24% of Americans have a will. Over half of adults lack any estate planning documents at all, which is inclusive of a will or a trust or other documents that kind of dictate what will happen to your belongings. In contrast, 43% say that they just haven't gotten around to it, while 40% believe that they don't have enough assets that makes making a will worthwhile. This kind of underscores that people think it's important, but they haven't taken steps to actually creating it. And one thing that's important that I found interesting is that the majority of the people that don't have wills make up the largest share of adults with dependent children. So your will can also include what happens to your minor children in the event that you or your spouse, if you have one, are unable to take care of your children. So what do I need for a will? Well, a lot of people think that they don't know where to start. So it could be helpful to consult a lawyer. And the State Bar of Georgia website lists all the attorneys who are currently barred in the state of Georgia and their practice area. So if you have a specific need, for instance, if you want a probate attorney or a wills and estate attorney, you can go to the website and search specifically for that, and they'll give you a list of all the attorneys who practice in that area. And you can click on their link, and they'll have a bio of that attorney and how long they have been practicing, and a little blurb to kind of help you decide who you want to select as your attorney. The Georgia Department of Aging Services also has a resource if you're 60 years or older, or if you have parents that are 60 years or older. They have legal aid resources that kind of offset the cost of having an attorney or offset the probate costs. That would be helpful. So another thing you need to think about after you decide whether you want to have an attorney is who do you want to be the executor of your will? And this really needs to be someone that you trust and someone that you can rely on to carry out your wishes after you're gone. So after you have passed, your executor will be the person that will submit your will to the probate court and have it officially carried out. So if you don't name an executor and your will is probated, then the court will assign an executor of your will. So if you have a will and you name an executor, then it helps to decide exactly who it is, and it doesn't leave it up to the chance of the court. And you can also think about who will be the legal guardian for your children. And if you have any loved pets that you have, some people want to make sure that they're taken care of in the event they're no longer able to, and they designate someone to take care of their pets in their will. Okay, so just to recap, the options for creating a will, you can consult an attorney, or if you, not to recap, to kind of go along, you can consult an attorney, or if you choose to do it pro se, which means without an attorney, then there are helpful templates or creating tools that are available online. And these are just two that I found the most helpful when I did a Google search for websites that help people create wills. And so it's freewill.com and legalzoom.com. Both of these list step-by-step instructions, and you can also find the step-by-step instructions on the state of Georgia website for creating a will. Okay, so before you actually get to drafting the will, this is what you need to think of. The first thing is all of your assets, whether it's property you own, if you own any cars, if you own mobile homes, if you have any jewelry or clothing that you would like to designate to go to a specific person, if you have money in bank accounts, or you would like to designate a specific person to receive your 401k, any investments or pensions or life insurance policies. So you want to get a picture of what everything you have, all of your assets. So whether that's just a few items or it's a lot of items, it's important to list it all out so that you can account for everything once you start drafting the will. Because if you start drafting it and then you're listing it out, sometimes you might forget. So it helps me to just list everything out. Then I can see, oh, this is what I have and this is what's missing. The next thing you want to decide is who are going to be your beneficiaries. So you can have loved ones to be your beneficiaries. You can also designate organizations like our beloved LaGrange College to be a beneficiary of a specific gift. And if you have the beneficiary form, most organizations will have you fill out a beneficiary form. If you have, like, for example, with work and your 401k, a lot of times they'll have you list your beneficiaries. It's important to make sure that who you list as your beneficiary in those forms will also match who you list as a beneficiary in your will, because often if they conflict, the beneficiary forms for those individual items will that will override anything that you may have in your will. So it's important that they match so there's no confusion about who gets what. And the other thing is decide who will be your witnesses. So your witnesses for the will must be different from your beneficiaries because they need to be witnesses that can testify to the fact that you were of clear and sound mind when you drafted your will, and they can testify that they don't have any stake in the outcome. In the event that the will is contested or anything like that, they can say, oh no, I was a witness to this. This is what the individual intended to occur, and I have no stake in the matter. So once you have these three things listed out, now you're ready to write your will. So how do you write it? So you can take a sheet of paper or you can type it and then sign it later. But you want to make sure that it's very clear that this document is intended to be your last will and testament. And a lot of times people will include the statement, this will and testament overrides or nullifies or invalidates all other previous wills, so that people know that what they're looking at is actually the most current version of your will. And you want to make sure that your full name is on the will and your address so that it's identified, because a lot of times, or not a lot of times, when people die, there's a death certificate, and on your death certificate it's your last place of residence. So it's important for that death certificate to match what's on the will, because it's easier for your executor to be able to prove that it is your valid will. So you also want to name who your executor is in the will. So you don't just want to think about it or have decided it internally. You have to make sure that that person is included in your will, and it's clear that you intend for this person to be the one who carries out your wishes. You also want to list out anybody who you have appointed to care for your children or care for your pets, and make sure that is clearly written that that is what you desire to happen. So then you have your assets, and now you have your beneficiaries. So your will tie the two together. You can list out clearly who you want what to go to. A lot of times I know we've probably all heard of situations where someone passes away unexpectedly and they have assets, but there's no will, and the family is unclear about what they wanted to occur. So now everyone is kind of scrambling to decide what happens, and this list of beneficiaries and list of assets can make it very clear who gets what and when and why. If you even want to have a little letter explaining why you're given, or a note in the will why you're giving each person that. Of course, that is completely voluntary. And again, that's deciding how complex you want your will to be. And this is also important to know that if you want to specifically exclude someone from your will, you can make it clear that this person is not to have X possession or any of your possessions. So that's something that you want to include as well. Now, most states have this presumption that if you leave anything to your spouse in your will and you and your spouse end up terminating the marriage, then whatever was to go to the spouse is no longer to go to them. So if you and your spouse part on amicable terms, and you intend for them to still have things in your benefit in your will as a beneficiary, it's important to update your will and let whoever is executing the will know that, yes, we parted terms, but this person is still to have what I designated them to have. So lastly, you want to make sure to sign your will, your handwritten signature. Most states still require the handwritten signature. I would have to double check specifically for Georgia, but I believe most states still require a hand signature. And then make sure that you sign it in the presence of your witnesses, because those are going to be the people who will be able to attest to the fact that you signed in clear of sound mind. Okay, so now your will is drafted. What do you do? So once you have finalized the will, you've signed it, your witnesses have signed it, then you want to make sure to keep it in a safe location. This could be somewhere in a safe at your house. This could be in a safe at a bank. But it's important that only your executor has access to the will. Or if someone else has access, it's a trusted person. But as long as the executor has access to it, because a will is can be executed once a person has passed. So if you trust your spouse or your kids or a trusted friend, make sure to tell them so that someone can find the will and have it executed, but most importantly, the executor. A will is valid and doesn't expire after a certain time. It doesn't have to be notarized or anything like that in order to be submitted to the probate court. So as long as it's signed by you and signed by the witnesses, then you can have it, then it's a valid will. So after your will is drafted, it's also important to work on an overall estate plan. So a lot of people have trust that they will put property into, or they'll designate a trust for their kids, and a trust is a part of an estate plan. So if you want to expound on the will or expound on how your belongings will be allocated, it's important to also develop an overall plan, because you can also include what happens to your remains if you want to be cremated, if you want to be buried alongside family members and you have a certain plot. All of these things are important to plan for if that's something that you wish to have control over or a say-so in upon your death. Okay, and it's also important to update your will after big life events. For example, if you get married, it's important to update your will. If you have a child, it's important to update your will. If you purchase new property, or if you have a death of a loved one who is named in your will, and now you want to redesignate an asset to a new beneficiary, it's important so that all of the people who you would like to leave something to in a meaningful way know about that and are able to carry out your wishes, your last wish, because this is the last big decision that you will have a say-so in after you're gone. Again, you can designate some of your assets or monetary gifts to be given to a specific organization, like LaGrange College. And if you do, it's also good to let them know so that they can make arrangements for that. Yes. So now that we have gone in depth talking about the will, or given a brief overview to kind of let you know what a will is and the importance, we're going to be having our next Lunch and Learn in October, where we will go a little more in details about estate planning, what a trust is, how to create a trust. So we hope that you will join us, and we want you to know it's not just for the wealthy. Just as for a will, everyday people need estate planning, and they need to have a will just to secure their desires after they're gone. So.
Well, Cheryl, thank you. We have time for some questions. Thank you for the presentation. There are a couple questions that have come up, and again, if you do have questions, feel free to drop it in the Q&A section. You mentioned a couple times probate. What exactly does that mean, and what happens if you don't put your will into probate? I mean, is that...
Okay, that's a great question. So to put your will in probate means that somebody has submitted your will to the probate court. So most states, if not all, have a probate court, and this probate court is responsible for deciding what happens to a person's estate after they're gone, whether they have a will or not. So once someone passes away and this has been recorded with the state, then there has to be an allocation of their property. So if you have a will, to probate it means that you submit it to the court and say, hey, this person has designated what they want to happen to their belongings. This is a valid will. It was signed by the decedent and the two witnesses. So here, this is for the probate court to evaluate the validity, which most often they accept, and say, okay, this will now be carried out pursuant to the decedent's wishes. So that is the process of having the will probated. So if you don't have a will probated, then this is what creates issues with the loved ones left behind. So say a person has a will but never tells anybody where it is and no one can find it. So then the will can't be probated because there isn't a physical copy of it. So then the court will designate who is going to be the executor. And sometimes a loved one will make a petition to the court and say, hey, I have grounds to be the executor, and here's XYZ reasons for me being appointed. And the court will look at those and say, okay, I think this is a good reason this person can be appointed or not. So then the estate will go through probate without a will. So probate is mainly the process of having an estate or having a decedent's belongings distributed.
Now, you mentioned executor. I know in things have happened in my family, for example, that where we had a parent and there were multiple children, and they didn't want to make one child feel bad, so they named them all co-executors of the will. Now, in our experience, that was a bad idea. From the legal perspective, is that also a bad idea, or is that okay?
Yes, no, that would be a bad idea. I would not recommend appointing multiple executors because sometimes two different people will have two different interests. And although the executor ideally is carrying out the wishes of the decedent, but if there are multiple executors, then the likelihood that there's confusion about what the decedent actually wanted increases. So it would be good to appoint just one person who can really carry this out to avoid all of that.
Okay, and we have some questions from our Q&A. A couple from Laura. Does the state of, oops, for some reason that happened. Does the state of Georgia recognize common law marriage? If so, after what time period?
So I would have to double check because I don't practice in Georgia. So I can double check, but I believe that Georgia is one of the states that does not recognize common law marriage unless it is a common law marriage that was validly entered into in another state. So if another state recognizes a common law marriage and the common law spouses move to Georgia, then Georgia has to recognize that marriage as well.
Okay, and then a follow-up question. I believe there's also a thing from Suzanne who indicated that no, in fact, that is not recognized in Georgia. Common law is not recognized in Georgia. So another question, what if I have no children or living relatives? What happens if I do not designate an executor?
If you don't designate an executor, but you still have a will and someone finds your will, they can submit it to the court, the probate court, and the probate court will select an executor and so it'll be a court appointed executor. And of course, if your loved one finds it and wants to be appointed, they can always make a petition to be appointed as the executor after the fact.
And this question bleeds over a little bit into our October webinar, which I hope everybody comes back for. It's which items should go into a living trust as opposed to a will?
That's a good question. So there are pros and cons, and I think our webinar in October will be able to go into this a little bit more. And I mainly, when I deal with wills, I mostly deal with just property and not everything else. So our next presentation could probably clear this up a little bit more. But what I see most often is people put property in trust and they also put money in trust aside for their children. But you can pretty much put anything you want in a trust. I think it That's why I would recommend talking to an attorney that specifically practices in like wills and trusts, because they could guide you and hear your specific circumstances and your specific assets to determine what should go into the trust versus what should go in just the will.
Okay. And then another question, can the executor be a beneficiary?
No. So,
No, I think the executor can. I think the witness can.
Yes. Sorry. The executor can be a beneficiary. Sometimes people think it's better to choose someone who is not, who doesn't really have an interest, to make sure that it seems unbiased. But I believe that, and again, every state is different. So for Georgia, I would have to double check. But I think the beneficiary can be the executor, but it's not recommended.
Now, we'll tell you one thing that to me is worth the price of admission learning today is that if you have a beneficiary listed on something like a 401k, that trumps what is in the will. And I think a lot of people don't really realize that, because you think the will is kind of the all-encompassing part to things. And let me see if we've got any other. Is there somebody? Oh, here we go. Next question. Well, Cheryl, does notarizing a will give it any more validity than not, even if it's not required? Is it good practice? And Mark Shepard says, shout out to Metro from the Metro DC. So.
I mean, I think it's important to have documents notarized just as a general practice, but I'm not sure that the court recognizes it as more valid than a will that's not. It's either valid or it's not. So I don't think it gives it any more authority if it's notarized.
And Mark, thank you for the nice birthday wish. Yeah, it was my birthday 2 days ago. So. We'll probably have time for maybe one last question. If anybody has anything, let me check the Q&A and check the chat again just to make sure. So I will ask one thing. Sometimes you have a situation where, and this, you see it more in movies than anything else, of, oh, all of a sudden another new will just kind of shows up out of the blue. If you've got two wills and like that situation happens, and supposedly it's very different than the first will, does just the fact that if it's signed later and it has the witnesses, does that tend to be the thing that goes, whatever the latest will you do?
Yes.
Takes precedent.
Generally, the more recent will is what overrides all the others.
Okay.
But this, if it's not specifically stated, then it allows room for people to come in and contest the most valid will and say, oh, this one actually wasn't valid because XYZ happened, especially if there has been a big life event that happened and that will doesn't say this overrides, then, someone could come in and say, oh, well, I'm contesting this will because they just got married and they actually weren't in sound mind and they started to have health issues and the new spouse knew that, or something of that nature. So it just eliminates the ambiguity if you clearly state in the will that that this invalidates all previous wills and codicils.
Okay. We have time for one last question, and it's from Sandra. It says, is a will specifically for execution when an individual passes, or can it be executed while the person is alive at that person's will?
That's a great question, and it actually, a person has to have passed away for the will to be executed, or excuse me, for the will to be probated. So you execute the will by signing it, but the executor of the will is who oversees the probate part. So I know those words are a little similar, but yeah. So the person has to pass away for the will to be probated and the assets distributed.
But there's some different things you could do with trust, right?
Correct.
Yeah.
Correct. Yes.
Which again is a good segue.
Yes.
Week of October 20th, we will have our next session on estate planning, which will include wills and trusts. Well, Cheryl will be back with us, and also Peyton Smith who's an attorney in Atlanta who works pretty exclusively with wills and trusts. So again, thank you guys. We'll shout out from Sandra. So thank you, Loishirl. Great job, Mom.
Thank you.
Always good validation right there.
Yes.
Laura, thank you. Mark, thank you. Stephen, thank you. Glad you guys could join us. And again, join us in October for our next session on wills and trusts. So
Yes.
thank you all very much.